An introduction to Islamic law. Well, we hallaq. It's a Cambridge book. So let's begin with chapter 1, tradition and continuity. Who's who in the Sharia? In modern legal system, judge, lawyer, notaries are unquestionably products of the legal profession. They are initially educated in elementary and secondary school that are regulated by the state. Their education in the law school from which they eventually graduated is no less subject in to such regulation. They study the laws that the state legislates, although in some legal system they also study the legal decisions of judge who are constrained in good part by the general policies of the state. The point is that the legal profession is heavily regulated by the state and its legal and public policies. It's difficult to think of any legal professional who can go on to practice law without having to pass some sort of exam that's directly or indirectly ordained by the state or its agencies. And when law student become lawyer become judge, their ultimate and almost exclusive reference is to law made by the state. This situation would have been inconceivable in Muslim lands before the dawn of modernity. Most striking fact about traditional Islamic legal personnel is that they were not subject to the authority of the state, simply because the state as we know it did not exist. In fact, it did not exist in Europe either. Its beginnings there going back to no earlier than the 16th century, thus until the introduction to the Muslim world during the 19th century of the modern state and its ubiquitous institution. Muslims lived under a different conception and practice of government. This is why we must not use the term state to refer to that early form of rule under which Muslims lived prior to the 19th century. Instead, we'll reserve for that kind of authority such terms as ruler, rule, or government. Pre-modern Muslim rule was limited in that it did not possess the pervasive powers of the modern state. Bureaucracy and state administration were thin, mostly limited to urban sites, and largely confined to matters such as the army of the ruler, his assistants, tax cancellation, and often land tenure. People were not registered at birth, had no citizenship status, could travel and move to other lands and regions freely. There being no borders, no passport, no nationalities, no geographic fixity to residential status. A Cairene family, for instance, could migrate to Baghdad without having to apply for immigration, without having to show documentation at borders, because as I said, there were neither border not fixed at any rate, nor passport in the first place. The further people lived from the center of rule, the less they were affected by the ruler, his armies, and his will to impose a certain order or even taxes on them. And the reason for this was simple. In order for the ruler to have complete control over faraway reasons, he had to send armies and government officials whose cost of maintenance may not always have been covered by the taxes they live from the population under their control. So, if there was no state to regulate society and the problems that arose in it, then how did people manage their affairs? The short answer is self rule. Communities, whether living in city, quarters, or village, regulated their own affairs. If the civil populations felt it necessary to have a ruler, it was because of the specific need for protection against external enemies, be they raiding tribes, organized highway robbers, or foreign armies who might wreak violence on them and play havoc with their lives, but the civil population did not need the ruler to regulate their own internal affairs. Since such regulation were afforded by a variety of internal mechanisms developed over centuries by their own local communities, customary law was an obvious source of self regulation, but the Sharia was equally as important. This is to say that the Sharia was not the product of Islamic government, unlike modern law, which is significantly the product of the state. It is true that the Muslim ruler administered justice by appointing and dismissing judges, even defining the limits of their jurisdiction, but he could in no way influence how and what law should apply. So the question before us is, if Muslim ruler did not create the law of the land, who did? The answer is that society and its communities produced their own legal experts, persons who were qualified to fulfill a variety of functions that in totality made up the Islamic legal system. For now, we will speak in a limited fashion and by way of an introduction of four types of legal personnel who played fundamental roles in the construction, elaboration, and continued operation of the Sharia. These are the Mufti, the author jurist, the judge, and the law professor. Of course, there were other players in the legal system, including the notaries, the court, witnesses, and even the ruler himself, to be discussed in the due course. But their role in the construction of the system and its continuing operation was not structural, by which I mean that the system would have remained much the same with or without their participation, but without the fundamental contributions of Mufti, author, jurist, judge, and law professor, the Sharia would not have had its unique feature and would not have developed the way it did. These four pairs, each in his own way, made the Sharias what it was. We begin with the Muftis because of his central role in the early evolution of Islamic law and his important contribution to its continued flourishing and adaptability throughout the centuries. The Mufti, performing a central function, was a private legal specialist who was legally morally responsible to the society in which he lived, not to the ruler and his interests. The Mufti's business was to issue a fatwa, namely a legal answer to a question he was asked to address. As a rule, consulting him was free of charge, which means that legal counsel was easily accessible to all people, poor or rich. Questions addressed to the Mufti were raised by members of the community as well as by judges who found some of the cases brought before their courts difficult to decide. The first legal elaborations that appeared in Islam were the product of this question answer activity. With time, these answers were brought together, argumented, systematized, and eventually transmitted in memory as well as in writing as law books. The Mufti stated what the law was with regard to a particular factual situation, as he was, because of his erudition, considered to have supreme legal authority. His opinion, though non-binding, nonetheless settles many disputes in the court of law, thus regarded as an authoritative statement of law. The fatwa was routinely upheld and applied in the courts. A disputant who failed to receive a fatwa in his or her favor was not likely to proceed to court and would instead abandon his or her claim altogether or opt for informal mediation. Muftis did not always sit in court, but this did not change the fact that they were routinely consulted on difficult cases, even if they resided at several days' distance from where the case was being decided. It was not unusual that a judge, say in Cairo, would send a letter containing a question to a mufti who lived, for instance, in Muslim Spain. The authority of fatwa was decisive. When on occasion a fatwa was disregarded, it was usually because another fatwa, often produced by an opponent constituted a more convincing and better reasoned option. In other words, and to put it conversely, it was rare for a judge to dismiss a fatwa in favor of his own opinion unless he himself happened to be of a juristic caliber higher than that enjoyed by the mufti from whom to fatwa was solicited, in which case the judge himself would not seek a fatwa in the first place. All this is to say that the fatwa is the product of legal expertise and advanced legal knowledge, and the more learned the mufti, the more authoritative and acceptable his fatwa was to both the court and the public. The level of a scholar's legal knowledge was determined through practice, not degrees or diplomas. The measure of a leading jurist was, among other things, the quality of his writings and fatwa, as well as his ability to win the scholarly debates with distinguished scholars. The central role of the fatwa in the Muslim court of law explains why the decision of judge were neither kept nor published in the manner practiced by modern courts. In other words, law was to be found not in the precedent established by courts of law, a notation based on the doctrine of stare decisis, but rather in a juristic body of writing that originate mostly in the answer given by muftis, thus emanating from the world of legal practice. The fatwas rather than court decision were collected and published, particularly those among them that contained new law or represented new legal elaboration on older problems that continued to be of recurrent relevance. Such fatwas usually underwent a significant editorial process in which legally irrelevant facts and personal details, proper names of places, dates, etc., were omitted. Moreover, they were abridged with a view to abstracting their contents into strictly legal formulas, usually of the hypothetical type. If X does Y under a certain set of conditions, then L legal norm follows. Once edited and abstracted, these fatwas became part and parcel of the authoritative legal literature to be referred to and applied as the situation required. The great majority of Islamic legal works, however, were written not by the mufti but rather by the author jurist, who depended in good part on the fatwas of distinguished muftis. The author jurist activity extended from writing short but specialized treatises to compiling longer works, which were usually expanded commentaries on the short works. Thus, a short treatise summing The law in its full range usually came to become 200 pages, often illustrated commentaries occupying as many as 10, 20, 30 large volumes. It was these works that afforded the author jurist the opportunity to articulate each for his own generation a modified body of law that reflected both evolving social condition and the state of the art in the law as a technical discipline. The overriding concern of the author jurist was the incorporation of points of law. For the most part, was that had become relevant and necessary to the age in which they were writing. This is evidence in their untiring insistence on the necessity of including in their works much needed legal issues deemed to be relevant to contemporary exigencies, as well as those issues of widespread spread occurrence. On the other hand, cases that had become irrelevant to the community and its needs, and having thus gone out of circulation, were excluded. Many, if not the majority, of the cases retained were acknowledged as belonging to the later jurisprudence, who had elaborated them in response to the emerging new problems in the community, reflecting in their writings the changing conditions of people and of the age. The author jurist opted for later opinions that were often at variance with the doctrines of the early masters. It's also instructive that the fatwas that formed the substance of the later doctrine were those that answered contemporary needs and had at once gained currency in practice. On the other hand, those opinions that had ceased to be of use in litigation were excluded as weak or even irregular. Many of the works written and published by the author jurist served as standard reference for judges who studied them when they were students, consulted them after being appointed to the judiciary. Hence, if the authority of the law resided in the mufti's opinion and the author jurist treatises, then the judge, unless he himself was simultaneously a mufti and or an author jurist, was not expected to possess the same level of expert legal knowledge. This is to say that a person who was a mufti or an author jurist could usually function as a judge, although a judge who was trained only as a judge could serve neither in the capacity of a mufti nor in that of an author jurist. If it is obvious that the business of a judge is to adjudicate disputes, which is indeed the chief task of modern judge, but this task was only one of many other important duties that the Muslim judge, the Qadi, had to undertake. And the Qadi, like Mufti, was a member of community he served. In fact, Islamic law itself insists that a Qadi, to qualify for the position, has to be intimately familiar with the local customs, way of life in community in which he serves. With the help of his staff, which we will briefly discuss in due course, he was in charge of supervising much in the life of the community. He oversaw the building of mosques, streets, public fountains, bridge. He inspected newly constructed building and the operation of hospital, soup kitchens, audited, among other things, the all-important charitable endowments. He looked into the care afforded by the guardians to orphan, the poor, and himself acted as a guardian in marriages of women who had no male relatives. The Qadi oftentimes played the exclusive role of mediator in cases that were not of strictly legal nature. Not only did he mediate and arbitrate disputes and effect reconciliations between husband and wives, but he also listened, for example, to the problem dividing brothers who might need to know more than an outsider's opinions. Yeah, Allah, it's very big chapter.